good morning and happy Saturday. I hope everybody is planning on getting out and enjoying this beautiful weather that we're having here in southern Minnesota today. I'm Meghan Maes, and I am an attorney licensed to practice in the state of Minnesota. I'm the owner of Maes Law, and this is a place where I have dedicated Saturdays at 10 to answer questions about family law and provide information and free resources. What this is not is legal advice, and I am not your attorney, so this is just a great place for information, asking questions, because I think there's a lot of great resources out there, and I want to make sure people know where those are at. Hi, good morning, you guys. Good to see you. So I have chosen to talk today about parenting time, and so that's what we're going to be talking about today. I want to thank everybody who tuned in last week. We talked about the Minnesota Judicial Branch, and we talked about custody and presumptions of parenting time, reminding you that in the state of Minnesota there's a minimum presumption of 25% parenting time. Hi, good morning. And so that's kind of what the bar is. You go into court and it's kind of presumed that each parent will get 25% of the parenting time. Hi, good morning. Oh my gosh, good to see you guys. If you have questions or comments, go ahead and put them in the chat. We're going to be talking about parenting time today. So in the state of Minnesota, there's a presumption of 25% parenting time. Well, what does that mean? And the court typically looks at parenting time based on how many overnights that you have. So you count up the number of overnights, and then out of 365 days, you can just determine what percentage of parenting time. There is, I think, a misconception that every other weekend is 25%. If you do the math, it's actually 4 overnights every 2 weeks. So I'm curious what kind of parenting time schedules people have out there. In the state of Minnesota, I hear sometimes that it's a mom's state. There is not anywhere in the rules that says it's a mom state. However, if you are not married when you give birth as a mom in Minnesota, you have custody of that child. And the legislature, the people who make the rules, say that if you birth a child, you get to have custody because it's very easy to identify who the birthing parent is, right? When you are not married and you're not the birthing parent, it can be scary because you don't have any rights until either you and your partner come to some kind of an agreement or the court issues a order giving you those rights. There is a form called a recognition of parentage, and that is signed at the hospital. A recognition of parentage, it still doesn't give you the right to say I have a certain schedule until there's a court order. So today I kind of wanted to talk a little bit about that. So yes, mothers in the state of Minnesota, you do have the ability to make decisions on your own for the care and custody and parenting time of your kiddos. If somebody brings you to court, the court is going to look at the circumstances prior to the court getting involved. So whether or not there's a relationship between them, whether or not parenting was denied, whether that reason was a good reason. There can be good reasons to deny parenting time. And so if you have, if you're experiencing safety concerns, certainly I don't think that would be the best time for the other parent to run into court, but people do it all the time and I can't stop them. So the first thing to understand about parenting time is who gets to decide and how do you decide? Well, if there's no court order, then you guys can work together as co-parents to establish something. You don't need a document. The reason why a document is important, however, is when people don't follow the court order. That can be so frustrating for a number of reasons. It can be very hard to plan, to schedule, to count on the consistency of the other co-parent when you are, when you have a co-parent that you are trying to encourage a relationship with. So even if there's a recognition of parentage, even if the parent is paying child support, even if there's a set schedule that you guys are operating under, if you want that to be enforceable, it should be put into a court order. So how does that happen? Well, one is you can both go to court together and you can say, this is what we agree to. A court will issue an order and both you and the other parent will have to follow the order. Now, do people always follow the court order? Does anybody out there have a partner or somebody that just can't 100% comply with the court order? Yeah, probably everybody, because we're imperfect humans, and I've been late before. Don't take my kids. But you know, there's a level of reasonableness. Is the behavior reasonable, or are they being unreasonable? And what can a court do about that? So if you do have a court order, great. What should be in that court order? Well, if you're talking about a parenting time schedule, the questions I would have is, what time does it start? Where will the exchange take place? Who picks the kiddo up from school that day if you get a phone call from a nurse or there's an emergency? Who's the on-duty parent for that stuff? Having a location and a time makes it very easy if you need to show that someone is not following the order. If your order is a little bit more loose and it just says the schedule as agreed upon by the parties, and that works for you, love it. Sometimes, for whatever reasons, COVID, global pandemic, people lose their minds though sometimes, and they don't always follow the court orders. So what can you do? Well, for me, what I would want to know first is, what are your goals, right? If you have a parenting time order and someone isn't following it, what's your goal? Sometimes the goal is immediate safety. And if immediate safety is your goal, there are ways that you can go into a court and say, I'm experiencing extreme, unsafe situations. I'm not physically safe. My kids are not physically safe. A court could issue what is called a restraining order. And there are two kinds of restraining orders that I see quite often in family court. Is a order for protection, which can protect a individual from acts of domestic abuse that are defined by the statute, and there are just certain things that qualify, or a harassment restraining order, which can be granted if there are repeated and unwanted acts, words, or gestures that impact your safety, stability, security. So, if you need something immediate, a restraining order can be an option for you, but it's not an option for everybody. And so the advice cannot continue to be, just go file for an order for protection. The courts are overworked. It is not the place and time to address things that don't rise to the level of high lethality concerns. What are high lethality concerns? What is even high lethality? I get that question a lot. Well, it's not low lethality, it's high, right? So it's a big chance. And lethality means lethal, dying. I think in the state of Minnesota last year, there was a record number of intimate partner homicides. And so those are the cases that are high lethality. Indicators of high lethality, it is not a science. I am not sitting here trying to be the expert on this. I I just know a thing or two because I've seen a thing or two. And strangulation, or having disputes about children, or having a court involved. Things that can provoke the perpetrator into escalating their behavior. And as many victims know, sometimes you make yourself small and sometimes you make yourself big, and you have to do what is safest for you in that moment, but those are certainly options. If it's not that kind of an emergency, if you're just like, I can't believe that the other parent showed up 5 minutes early for parenting time. I'm sorry, that is not a reasonable thing to necessarily be upset about, unless they're out there honking. Just civil court is a place of reasonableness, of civility. So you have to be reasonable. If you want to just enforce the order, there is a process called contempt of court. And the Minnesota Judicial Branch has court forms on the website that can walk you through the process to bring your issue in front of the court. If you want to know more about what contempt is, that is certainly a very specific tool in the tool belt, but you can learn more about it at lawhelpmn.org. Contempt. Now, that is the nuclear option, right? Because with an action for contempt, the other party actually has the threat of going to jail if they can't knock it off. If they cannot help themselves, they just continue to just touch that hot stove, just can't handle it. Well, that's when the court can come in and be like, we have a nice facility here in our county that I would love to offer some housing for you if you can't get it together. And sometimes people go to jail over this stuff. It does happen. It should not be the goal or the likely outcome, because most people don't want to go to jail. Some people, it's beyond help. I digress. A less nuclear option would be something called a motion for parenting time assistance. So parenting time is about the schedule, and assistance means I need help. So if you're not trying to change a whole lot, if you're just, I want to move our location from my house to the county law enforcement center or the supervised visitation facility, that is a very reasonable request. And you could just ask the other parent, and the other parent could say, yes, I would love to agree to that. Unfortunately, when you are co-parenting with an individual with a low ability to view their behavior objectively, which is one of the traits of narcissism. I don't want to use that word because it means way too many things. So when you tell a court you want assistance because you're dealing with the N word, being narcissist, describe the behavior to the court. The court cannot change the way that you believe that this person is a narcissist, but they're not going to go to therapy and get diagnosed. So that's out of the picture. Describe the behavior. What is the behavior? And let the court determine objectively, is that person being reasonable? And most of the time they're not. So you can ask for parenting time assistance. And then there's also a way, if you want to change what the order is, you can file a motion to modify parenting time. If you have a current court order that has below 25% for the other parent, you are risking, the presumption happening if you go back to court, if you want it to go to 0. If somebody has just gone off to another state and moved on with their life and left you holding the bag for your family and providing the entire care for your kiddo, there's a way to change the parenting time schedule that will acknowledge the actual caretaking that is done for the kiddos in your family. Hi, thanks for coming. All right, one comment. Thank you, Lindsay. If we have 50-50, but the schedule is no longer benefiting my children, how do I go about modifying the schedule? Okay, that was asked 7 minutes ago, so I hope that I've answered that question. But what you would do is you would file a motion to, if you want to change your schedule, file a motion to modify parenting time. The court forms on the Minnesota Judicial Branch will walk you through the information that a court can consider in changing that. If you want to change it, and I did not come up with this rule. If you change it above a certain percentage, then there is additional information that you have to show to the court, and that is because a court views it going above a certain percentage as a restriction of parenting time if it's been pretty close to that, equal. And when you want to restrict someone else's parenting time, you have to show that they're just willfully, intentionally not following the court order, or that there is significant safety concerns, mental, emotional, developmental kind of concerns, behaviors that are negatively impacting the children. Then that information is also included on the court forms, so you would add that information as you see fit. What if you have 50? Thank you for that. Hi, Ashley. Good to see you. Okay, you said, what if you have 50-50 custody and the other parent won't give them back at the ordered time and place? How long would it take to get an emergency relief from the courts? Absolutely great question. Hate to say that it depends. I've practiced in, 20 different counties in the state of Minnesota, and the ways that cases are processed, the way that they are scheduled, the way that they are, their ability to be responsive based on their caseload varies drastically from county to county and judge to judge. If you go in on what is called an emergency basis, they are required to put that case higher up on the priority list because the courts want to keep people safe. Those circumstances, you could get very quick relief from the court. If you do want to modify it on a permanent basis, it is a two-step process. And this is based on a case, it's called the Neese-Peterson standard. And I'm from the south of Minnesota, and that's how we say it down here. If it's Neese, I apologize, or nice, I say Neese-Peterson. Anyways, it says you have to provide the court with significant information that says your kiddos are in danger. And if you can show the court that, then the court will give you what is called an evidentiary hearing, where you would go to court and the court would make a snapshot in time decision based on the information and try to stabilize things. But then they are going to make you come back and at an evidentiary hearing so the other parent can have an opportunity to explain the behavior or to defend themselves. If you're the person who is asking that your parenting time be restricted, you get to have a hearing on that. So how long would it take to get an emergency? Again, it can be as quick as they can get it taken care of. Something that might help is to follow up with court administration. When I have a case that I'm filing and I want to have quick, I need certain relief, I will just call court administration and I will say, hey, I'm letting you know I just submitted something through the e-filing system. It has to make its way through this data review process before it gets uploaded into the actual system, at which point then it gets distributed to the proper authority for their review. And that can sometimes take 2 days. And I don't always have 2 days for my clients. So I want to make sure that they know, and they're typically understanding that there are certain kinds of cases that do require a quick processing and getting it in front of the person who can be the helper as quickly as possible. So if you give them a heads up, then you can really go a long way. So I'm wondering if anybody is having any additional questions. We've talked about contempt, we've talked about parenting time assistance, we've talked about restraining orders, we've talked about emergency requests for relief. The one thing I do want to touch briefly on before I end today, if there aren't any other questions, is a couple years ago I did a training, and I think I'll add the video to the Being Civil in Minnesota group. It's called Help Me Get My Kids Back. And, you know, one of the most frustrating questions I get is if I have a parent who has either is not married and there is no court order for custody and parenting time, things were going well for a while, but all of a sudden now the other child is withholding, but they're paying child support and they're the other parent and their name's on the birth certificate. So it's hard to get law enforcement to, you know, enforce a statute because there's all this contradictory information and they hear all the stories, I'm telling you. Oh my gosh, Ashley, you just asked it. Can police help enforce a parenting time order? We are on the same wavelengths. Yes, they can. But in order to give them the authority to act, there are provisions that say in your court order, you can include that says law enforcement shall enforce the parenting time order provisions. And so that is certainly something that I would include. Law enforcement, when they have the ability to help, if they've got an order for protection and somebody's violating it, or if they've got a custody parenting time and some other parent is withholding the children, there's a crime for that. It's called a deprivation of parental rights. I think it's 609.26. And so there can actually be criminal consequences for behaving badly and withholding children. I don't see those charges as much as I think I would like to see them. But if you're going in and your order is clear, your time is clear, your location is clear, your documentation is chef's kiss flawless, screenshotting the time and yourself at the police station, you know, whatever it ends up being. I mean, that's whatever. You have to give the court the ability to help you, and a court is a very visual learner, and so you have to let the person behave badly in writing, in behavior, for a period of time, and the true characters will come out. So the option then is, if you can't get your kids back and you're an unmarried parent, there is something called an action for declaratory judgment. And I don't know if those are forms that are available on the Minnesota Judicial Branch website, but they are available, I believe, on Standpoint. I will follow up in the link. And basically, as an unmarried mother, you can go into court and ask a court to issue an order that says, yes, I declare that under Minnesota law, you have sole custody. Boom. At that point, law enforcement should be able to follow whatever the court order says. Take physical possession of the minor child from the care of the other parent and place it in the immediate care of, as specific as possible, while allowing law enforcement the deference and the discretion that they need to make sure that they're safe. Because obviously, you know, these situations can be very contentious. Another thing that can help police enforce a parenting time order is to have a copy of it. and make sure that you are providing all the information and that you are ready. So, it is so gorgeous out. I could talk about this for much longer than I am. I want to appreciate everybody for showing up today, and for those of you who will watch this after, please post your questions in the video comments, and I review those after these. So don't worry if you missed the live version, but I will see you guys next week. Take care. Bye.